Good morning. My name is Mark Dowling. I'm the Chief Executive Officer here with the Inland Valleys Association of Realtors, and I want to thank everybody for participating in today's webinar. Before we get started and I introduce our guest speaker today, let me just first say that it will be interactive, and in the event you want to ask questions for our speaker, you can do so. To do that, basically, if you go down in your Zoom app or laptop or whatever it is you're looking at, you could see a Q&A or a chat icon at the bottom of the screen or the top of the screen, depending on where it's located on your particular screen, and you can ask your question. And we'll be taking questions toward the end of the presentation unless something is really burning, and we'll interrupt our speaker and ask at that time. But I want to thank everybody for being here today, and let me get started by introducing Mr. Gov Hutchinson. Gov is the Assistant General Counsel and Vice President at the California Association of Realtors. Gov is in charge of the Legal Services program at their Los Angeles office, and he also advises on all of the legal hotline issues for the California Association of Realtors. Gov received his bachelor's degree at the University of Princeton, his Juris Doctorate degree from the University of Pennsylvania, and for more than 30 years, Gov has been a legal icon and pillar at the California Association of Realtors as he helps realtors navigate the always evolving, changing, and taxing world of real estate law. And with that, I will turn it over to Mr. Gov Hutchinson. Welcome, Gov.
All right. Well, hello, everybody. I've been doing this 35 years. This is the craziest year ever, as I'm sure a lot of you are experiencing. And it's also crazy in the legal world. A lot of stuff happening, a lot of changes. So I'm going to just sort of give you sort of an update of where we are right now with the legal stuff. I might as well start with probably the most significant thing that just happened yesterday or Monday. And that is, I know not all of you are landlords or property managers, but you probably have clients with rentals. And some of you may have your own rentals. Anyway, it's important to know what just happened because there's this really big law that just took effect September 1st. Now, you remember that the courts were closed for evictions all the way up until September 1st, right? So everyone said, okay, great, the courts are going to open, so now we can start doing evictions. But no surprise, the state legislature and the governor stepped in, and right effective on the date when the courts were supposed to open, they passed this new law, which is effective right now, which does a couple of things. First of all, the courts are still closed for evictions until October, okay? But starting then, they will be open for some evictions. But here's how it all works, basically. Bottom line is, let's say you're a landlord and your tenant hasn't paid their rent since sometime after March 1st. Well, you can't evict them for not paying that rent if they sign a declaration which says they have a COVID-related, under penalty of perjury, that there's a COVID-related reason why they are unable to pay the rent, okay? I'll talk about forms in a second. Now, so let's say you want to evict someone because they hadn't paid the rent sometime between March 1st and September 1st. You could send them this, starting on October 1st, you could send them this new notice to evict. It's a brand new form. It'll be out in a couple of weeks. It'll be out before October 1st. It's a 15-day notice rather than a 3-day notice. And on this 15-day notice, you're basically telling the tenant, okay, here's this declaration we've sent you. If you sign this declaration and send it back, then we can't evict you right now until February 1st. But they've got to say on this form, on this new declaration form, exactly under penalty of perjury that they have a COVID-19 reason why they're loss of income or increased expenses related to this, so they can't pay their rent. Okay. Now, starting September 1st, starting on Monday, tenants have to pay at least 25% of their rent. We're talking residential tenants now, including mobile homes, not commercial. Commercial evictions, you can go ahead. So, in other words, let's say they don't pay their rent for September. Well, they have to pay at least 25% of the rent. So you could give them in October a different notice. So there's going to be two 15-day notices. This is the one that says, well, you know, you didn't pay your 25% for September. So what about tenants who haven't been paid the rent for like, you know, May, June, July, August, September? To get the money, you're actually going to have to, or to evict them, you may have to send them two separate notices. There's the notice for the rent due prior to September 1st, and then there's the notice for the rent due after September 1st, in which case they got to pay 25% of the rent. So what if in the month of September, the tenant doesn't pay the 25%? Can I evict them right away? No. Unfortunately, they have until the 1st of February to pay the 25%. So theoretically, they still don't pay anything September, October, November, December, January. But then on February 1st, you could evict them for any of the rent that they haven't paid. What I mean is for any of that 25% payments they haven't paid. But if they made the 25% payments, does that mean on February 1st, I can evict them for all the rest of the money? And the answer is no. The only way you'll be able to get the money that they owe you is to sue them in small claims court. And small claims court, the jurisdiction is going to go above $10,000, so it'll be as high as it needs to be for you to sue for. So the bottom line is, any rent that tenants don't pay for a COVID reason, anywhere from February 1st, March 1st of this year, all the way to February 1st of next year, you can never get that money through an unlawful detainer. And you can't actually evict them. Now, obviously, you can sue them for the money they owe you, but you won't be able to evict them. The only way you'll be able to evict them would be if they don't pay that 25% that they're supposed to pay starting September 1st. So if they don't pay that, then on February 1st, you could evict them and collect that money. But if they pay that, you can't evict them. You can just sue them for the money. Starting February 1st, unless, of course, this is extended, then you'll be able to evict them. Now, starting in October, though, you will be able to do evictions for other reasons, right? Other reasons like they violate some other term of the lease or something like that, right? Then you would be able to evict them. Or what if they don't, you're selling the house and they're supposed to move and they don't leave? It's not a question of they can't pay the rent, it's a question of they don't want to leave. Well, you would be able to do those evictions. So the only evictions you can't do are the ones that involve they're unable to pay rent because of a COVID-19 reason. And starting September 1st, they have to pay at least 25% of the rent. And the only excuse they have for not paying all of it, once again, they have to sign a declaration under penalty of perjury that says they have a reason that's related. They have a COVID-19 either reduction of income or increase in expenses. If they don't sign that declaration, return it in 15 days, then you could evict them right away, starting in October, okay? Commercial, you can do any eviction you want, okay? I know this is complicated stuff, and obviously the forms, there's gonna be new forms, right? You no longer will be, if you want to evict someone, you have to give them this 15-day notice rather than a 3-day notice. And on the 15-day notice, this form will attach to it the declaration that so if they sign this declaration and send it back within the 15 days, then you can't proceed with the eviction. But if they do not return the declaration in 15 days, then you'll be able to proceed with the eviction. So all of this is going to end February 1st, supposedly. So there's going to be a new 15-day notice for tenants who didn't pay between March 1st and September 1st. There's going to be a new 15-day notice for tenants who don't pay the rent between September 1st and February 1st of next year. What if it's not a question of rent, but they're supposed to pay the utilities, or they have some other financial obligations they're not making? There's going to be a separate new 15-day notice to cure covenant or quit for those financial obligations between September 1st between March 1st of this year and September 1st, and then a new one for failure to do other financial obligations other than rent starting September 1st. So obviously there's going to be the new declaration form and believe it or not, there's going to be a new disclosure form you have to give to your tenants, any tenant who hasn't paid rent since March 1st for COVID reasons. Don't worry, all of these forms will be available soon. If you think about it, there's actually 4 new 15-day notice forms, a new declaration form, and a new disclosure form that you're going to have to give the tenants if they're not paying the rent and you want to get them out. Like I said, if you just don't do anything at all, you just don't get them out. But you can give them notice. If they don't sign the declaration, then you can get them out. If they don't pay the 25%, you can evict them starting February 1st. If you have another reason to evict, that's the big news. You can now at least do evictions for people who, there's another reason, like you're selling the house or something like that. If you're selling the house and there's a tenant there, you will be able to evict the tenant. But the bottom line is, another thing to remember is, remember in California, we have this thing called just cause now. Just cause law says, even if the tenant's paying their rent, you can't just evict them without a reason. You need a reason. Like they're doing something else wrong. You know, they have pets, they're subletting without permission, they're causing damage, they're doing any violation, you can evict them. But what if I got a tenant, they're paying the rent, but I just want to get rid of them? Well, we got this just cause law that says, right, I can't kick them out unless I want to move in myself or I want to just get out of the rental business. Then I can kick them out, okay? But guess what? This new law that just took effect also says single-family homes and newer buildings are under this as well. So if you remember, before COVID, if it was a single-family home or a building that's newer than 15 years, you didn't need a reason to evict. Just cause didn't apply. Well, now, up until February 1st, just cause applies even to single-family and even to buildings that are newer than 15 years. Bottom line, if you want to evict someone between now and February 1st, if they have a COVID reason to not pay rent, you can't evict them. What if you want to evict them for another reason? Well, you do need a reason. Single family home, you still need a reason. You're selling the house. The buyer wants to be vacant. That's a reason. You want to move in yourself. That's a reason. You want to get out of the rental business. That's a reason. They do something wrong other than not pay rent. That's a reason. They don't pay rent and they don't have a COVID reason. Those are all reasons. But you need a reason. In other words, up until now, if the courts were open and it was a single family or newer building, you didn't need a reason to evict. Now, between now and February 1st, all evictions, you need a reason to do it. And you cannot evict if the tenant has a COVID-related reason not to pay, and they sign a declaration under penalty of perjury saying they really have this reason. Do they have to provide documentation that they really have a reason not to, they really lost income or something like that? And the answer is no, unless it's a high-income tenant. What is a high-income tenant? A tenant who makes more than 130% of the median income in the county where you're in, like Riverside. We have a Q&A on all this. It just went up on the website yesterday. It explains all of this. It also explains how to figure out what the median income is in Riverside County. So if your tenant makes more than 130% of the median income, then they do have to provide documentation proving that they have this loss of income or the increased expenses. If it's a tenant who's not a high income tenant, all they have to do is sign the declaration under penalty of perjury that they have a COVID reason. complicated stuff. We have a Q&A on our website. I'll make sure Mark has it. We also have a one-page summary of this. We have all sorts of information. The forms will be out in a few days. You can't do anything till October 1st anyway, right? So the courts are still closed till October 1st. All right, let me talk about some other stuff. We can come back to this. Other stuff that's going on, none of the COVID rules have changed recently. No open houses is still the case. Anytime you want to visit a house, you have to submit the PED-V form to the listing agent before you get there. The listing agent must post near the entrance the PRE, the Posted Rules of Entry form, right? So any visitor submits the PED-V, the listing agent posts the Posted Rules of Entry at the entrance. The occupant or the tenant who lives there has to submit the PED-S. The listing agent collects all these forms. You must have the actual address of the property you're visiting on the PED form. You're supposed to do a PED form every day you enter. It should be signed maybe the day of entry or the day before, because your health situation can change. You remember, when you get to the property and go onto the property, you got to wear a mask, you got to wash your hands, you're not supposed to touch anything. And when you're in the house, it's one buying party at a time. There's no limit on how many buyers, as long as they're all together, or they're all part of the same group, you know, the same family or whatever. And everyone wears the mask, wash your hands before you go in, don't touch anything when you're in the house, and stand 6 feet apart from everybody who you're not related to or not living with. Now, remember, if you're in LA County, if any of you guys sell in LA County, it's stricter. There's only 2 buyers at a time that can be in the property, only 1 agent. You can't have the buyer's agent and the listing agent. So it's a little bit stricter, and the sellers can't be there either. That's LA County. But if it's not LA County, the seller can be there, both agents can be there, as many buyers as you want, as long as they're in the same buying family can be there. Either way, though, wear the mask, don't touch, wash hands. And remember, it's the responsibility of the showing agent, not the listing agent, the showing agent, unless the showing agent is the listing agent. It's your job, when the buyer shows up at the property, to make sure that there are extra masks if they didn't bring their own, to make sure there's extra hand sanitizer if they didn't bring their own, to make sure all the doors are open, make sure, weather permitting, one window is open, make sure all the light switches are turned on, and make sure the property has been wiped down between showings, meaning you got to wipe down all doorknobs, all light switches, all countertops, sinks, handrails, banisters, and believe it or not, toilets. I guess you could lock the bathroom and don't let anybody in, then you don't have to clean the bathroom. But bottom line, nobody likes this, but it's the showing agent's responsibility. Showing agent is usually the buyer's agent. But let's say the only agent showing the property happens to be the listing agent. Well, in that case, they're the showing agent, and it's their job to comply with this stuff. It's the listing agent that collects the PED-V forms, right? And they can be done electronically. So these rules have not changed for a while. In your offices, you can allow people into the office, but if you allow people into your offices, I'm saying if you allow other agents or clients into your offices, everybody's got to wear a mask. You have to log them in. You have to screen them, ask them if they're sick, or do that infrared thermometer. Put up signs reminding people to stand 6 feet apart and wear the mask. Now, if the office is just for the agents and you don't let anyone else in, then you don't have to wear the mask when you're inside, but you got to still be 6 feet apart. But if you allow anyone else into your office, you got to register their names. You know why? Because let's say 2 days after someone comes into your office, they get sick and they tell you, oh, I was in your office a couple of days ago and I just tested positive. You, the broker, now have to notify everyone who came into the office after that person was there to tell them, by the way, you were in my office after the, a couple hours after there was the sick person there. And you got to notify the local health department. That's why you got to keep track of people who come into your office if they're not the people who actually work there. And this is why you have to keep track of buyers and visitors who come into your listing, because if someone comes into your listing for a showing and a couple days later they test positive, they tell you, guess what, I'm positive, you got to go back and try to notify all the people that came into the house after they did. So you got to keep track of this stuff. It's a real burden, but it's what you have to do right now for the time being. This is not going to be forever, but this is what we got to deal with right now, okay? So those are the latest rules on the offices and the masks. When you're out, you should be wearing a mask too. Anytime you're working, you're out in the field working, previewing properties, whatever you're doing, you need to be wearing a mask. Even if it's not a showing, people who are outside working are supposed to wear masks in any business at all, okay? What else is going on? Those are the big two things, the COVID rules and the eviction rules. By the way, I don't know if Riverside County has any cities that have their own eviction rules. I don't think so. But like LA City has this very strict eviction rule. Well, this new state law supersedes that. And this basically, by the way, this law says that starting in February, if you don't pay the rent, the landlord can immediately sue you for all the rent you've owed. Now, LA City had this rule that says, well, you got to give the tenant 12 months to pay back the back rent. Well, that's not true anymore. This state law says you only have to give them one month to pay it back. So in other words, this new state law supersedes the local laws. Like I said, where you guys are, I don't think there are many cities out. I don't know if there's any cities out there that have stricter rules. Okay. What else is going on? Remember, no door knocking. Are you allowed to leave flyers in flyer boxes? That's a gray area. The law is very clear. You can't leave flyers at a showing. But it doesn't specifically say you can't leave flyers at a house that's not being shown. To me, if you can't leave it at a showing, you probably shouldn't leave it at other houses either, but I will admit there is no clear answer to that question, okay? So I can't say for sure. In my opinion, you shouldn't be doing it, but that's just my opinion. That's not, because I'm just saying it by analogy. If you can't leave flyers at houses that are listed, why should you be able to leave flyers at houses that aren't listed? Nevertheless, the law doesn't address that. Let's talk about forms for a second. Okay, so I talked about the COVID forms, right? There's that PED form that everybody signs before they visit the property, and the PED-S form signed by the occupant. There's the posted rules of entry form. You have to post at the entrance to the property. You got that. Then there are these new forms coming out in a week or so, the 15-day notices. If you want to try to evict a tenant, you have to give them this 15-day notice. And even if you're not trying to evict a tenant, if they haven't paid their rent, you're going to have to send them this disclosure form. All of this, it's going to start October 1st. We'll have the forms probably in a few days, long before that, explaining how to use them. Are there any other forms you need to know about? Well, there's just 2 new forms that have come out this year. One of them, and neither one is mandatory. One is called the Square Footage and Lot Size Advisory, Sfls. Remember, if you're listing a house and you're aware of different opinions on square footage, you must disclose to the buyer, well, the assessor thinks it's this, the appraiser thinks it's this, the seller thinks it's this, the builder thinks it's this. You got to disclose all the different opinions on square footage, and also all the different opinions on lot size. Maybe you only know one opinion. Maybe it's just in the MLS. Well, then the point is you now have a form to give to the buyer that tells them what the square footage number is and where you got it. Remember, you don't have to verify it, you don't measure it. This form is going to tell the buyer, you should measure it yourself if you're curious. There is no such thing as the official square footage. Everybody has an opinion. No one's opinion is right. No one's wrong. People measure it how they measure it. Lot size is a little bit different because there is such a thing as an official lot size. The official lot size is what the surveyor comes up with. But square footage is not. The point is there's this good form to give buyers not required by law. There's also a form called the Property Viewing and Open House Advisory, PVOH. Open houses are not legal yet, but they're still a new form. It's basically, if I were a listing agent, I would give this form to the buyer, anyone who wants to see the property, because it sort of warns the buyer, when you go into someone's house, you are assuming the risk. If the floors are slippery, there's a bump in the carpet you might trip over, there's a rock in the backyard you might not see and you might trip over, or the house is under surveillance, has hidden cameras. By giving this form to the visitor, the buyer, making them sign it, they assume the risk. And they can't come back later and say, well, I slipped and fell, or you didn't tell me there were hidden cameras, or this or that, because they've assumed the risk and the responsibility. So I think it's a good form, not required. So those two advisories just came out. A month from now, in October, there's going to be a new form called the Fair Housing Advisory, which is going to be a very simple form attached to the purchase contract, explaining to everybody what the rules are for fair housing. And not everyone's aware of what you're not allowed to do or not allowed to say when you're selling a house as far as discrimination is concerned. So this form will be a good advisory advising people. So you'll see that form coming out. And then those are the new forms. So we got the two new advisories I just mentioned, one the square footage, one the property viewing. We got the Fair Housing Advisory coming out in October. And there's all these new eviction forms coming out in a week or so, which you'll start using in October, okay? Any other forms you should know about? Well, there's one more thing I want to mention, and that is a form you've been using for your whole life, if you're like been around as long as me, is the Transfer Disclosure Statement, the TDS. Came out 34 years ago, believe it or not. I've been working C.A.R. 1 year. I remember the day it came out vividly. All of a sudden, there's this form that the sellers have to fill out, and the agents have to fill out and give it to the buyer. Okay, fine. This form, by the way, has 4 sections. Section 1 is called Substituted Disclosure. Section 2 is Seller Disclosure. Section 3 is Listing Agent Disclosure. Section 4 is Buyer's Agent Disclosure. Okay. Section 1, remember I said substituted disclosures? For the last 34 years, I've been telling realtors, just skip that section. The only time you're ever going to use that section is if the seller's going to actually hire somebody to submit a report that's going to substitute for the seller answering their questions. In 34 years, I don't think I've ever seen a seller do that. I don't think I've ever seen a seller actually pay someone to submit a substituted reports just so the seller doesn't have to answer the 16 questions that they're supposed to answer. So I've been saying I would just skip section 1. But now there's a new law that says you have to fill out every section of the TDS or the TDS is incomplete, which means now you can't skip section 1 anymore. Fortunately, there's a new box on section 1 that says no substituted disclosures attached. So my advice now is every time you sell a house and you're the listing agent, make sure your seller checks that new box in section 1. For the last 34 years, I've been telling agents, you might as well just skip section 1. You don't have to check anything. You can no longer skip section 1. There's a box to check. Everyone should check, unless I guess it's possible seller doesn't want to fill out, I don't know, maybe an REO seller or something. They might actually want to hire someone to answer their questions for them. Like I said, I don't think I've ever seen it happen in all these years. Because remember, all these questions that the seller answers on the TDS are just, are you aware? And everyone can answer those questions. Do you know it or you not? Are you aware or you're not? You just ask yourself, do I know it or not? You don't have to investigate it. So anyway, bottom line I'm saying is on section 1, don't skip it like you've been doing the last 34 years. Make sure the seller checks the new box that says no substituted disclosures attached. Okay? All right. That's updated with the forms. That's updated with evictions. Those are the COVID rules for now. Those are the office rules for now. Those are the mask rules for now. All of this may change in the next few months, hopefully. One day you'll be doing open houses the old-fashioned way, but right now, open houses, everything has to be by appointment only. The only people in the open house, in the house at any one time, have to be all together, related to each other, one buying party, and you have to clean the house before and after each showing. So obviously you can't do an open house. The whole idea of an open house is it's open. I can just show up and go in without an appointment and stay as long as I want. You can't do that. You have to make an appointment. You can't just show up. When you get there, it's one group of buyers. There has to be one buying party at a time, and it has to be emptied out and cleaned each time you have one of these showings. So no open houses yet. Okay? All right. You know what else we're seeing? We're seeing a lot of, I don't know about your market, but most of the places, a lot of the places I talk to are having a lot of multiple offers, right? Multiple offers and things like that. So we're seeing some funny things in offers. For example, we're seeing buyers write in their offer, my deposit is non-refundable. I will release it to you right now. That's not enforceable. Even if the buyer signs that, even if the seller signs that, even if the money gets released, if the buyer can't perform and they haven't removed their contingencies, they still get their money back, even though they agreed the deposit was non-refundable. Now, if they remove their contingencies and now they can't perform, yeah, based on liquidated damages, they'll probably lose their deposit up to 3% of the price. So if the deposit, some people have been putting higher deposits, more than 3%. There's no point in that because the seller can only ever keep 3%. Another thing we're seeing are people making offers like this. My offer is $10,000 higher than the next best offer you get. Is that enforceable? Yes. Here's the problem. If the seller gets 2 offers like that, neither offer is valid at all. Because obviously if you have 2 different offers and each one says my offer is such and such higher than the next best offer, but you get 2 offers like that, those 2 offers nullify themselves and neither one of those offers is a legitimate offer at all. Plus the other thing, of course, that you want to be careful on, if you're going to submit an offer $5,000 more than the next highest offer, you probably want to put a cap on that up to a certain amount. Otherwise, if they get another offer from their brother-in-law that's really high, you've got to pay more than that. Of course, if you put a cap on it, you're sort of telling the seller how high you're willing to go anyway. So I don't know. They're legal, but if you get more than one, it's all screwed up. And I don't see it necessarily how it really benefits people, but it is legal. You know what else I'm seeing? I'm seeing offers like this. My offer is the appraised value plus $10,000. But they don't say appraised by who? Whose appraisal? And what if the appraisal is down? Does that mean the seller has to lower the price to that amount? If you're going to do that, put something like appraisal plus. I would always tell the buyer to get a lawyer to try to draft it carefully to make sure that it's really clear. I mean, I'm sure it can be enforceable if it's properly drafted, but be careful, okay? Another thing we're seeing are buyers submitting these love letters with their offers, where they say, and you got to be real careful doing that because you don't want to disclose to the seller anything personal about you, like how many kids you have and what race you are, what nationality you are, what religion you are. whether you have a disability, because sellers are not supposed to make their decisions based on the buyer's personal characteristics. They're only supposed to make their decision on the objective numbers. So if you submit one of these letters with your offer, you're telling the seller personal things about yourself. So you're setting up the seller for a bad situation where they can be accused of discrimination. If I was a listing agent, I wouldn't even, if these letters got submitted, I wouldn't even let my seller see them. I'd say, you're being set up here. You know, you're going to be you could be in a situation where you're accused of discrimination because you accepted this offer or you didn't accept this offer based on the personal characteristics of the buyer. And how did you know the buyer's personal characteristics? Because they sent you a letter. They even had pictures. You see what I'm saying? So that's an issue we're seeing right now that you got to be careful about. What else is going on? I do have some good news as far as accessory dwelling units. Let's say you want to convert your garage and rent it out. You have the right to do it now. No impact fee. The government cannot say no as long as you get permits for the construction. But otherwise, and you have separate entrance, you're always allowed to do it. If you want to build a new separate detached accessory dwelling unit like a granny flat, if it's smaller than 750 square feet, automatic approval, no impact fee, as long as you meet the building code. The owner doesn't have to live there. The owner doesn't have to live in the main house. As long as it's no more than 16 feet high and 4-foot setback, you can do it. They can't say no, and they have to approve it within 60 days. And there's other rules too. If you're ever having and this applies to HOAs and governments. So if you're ever having pushback from the government or HOA allowing you to convert your space or to build a new one, call C.A.R. We got a lawyer. His full-time job right now is making sure that these cities and HOAs and counties comply with these rules and allow you to build the accessory dwelling units. Okay. Mark, are there questions maybe that I should look at?
There are a couple. One came in from Jesse Streeter. It says, hi, Gov. Should the potential buyer sign the open house advisory, or is this form just a handout at this point?
Yeah, you want them just to sign acknowledging that they got it. That's all.
Okay.
So that's important.
Okay. There was another question that came in from Joe Cusimano. The form that requires the 15-day period, right, does that include weekends?
It doesn't. Very good question. Mm-hmm. As you probably know, this year they changed the 3-day notice to pay or quit. It doesn't count weekends and holidays. Well, this new 15-day notice, which will be in effect, remember, from now and from October until February, same thing. The 15 days, they have 15 days to respond, not counting Saturdays, Sundays, and legal holidays. Okay, great. Great. Just to remind anybody, if you have any questions for Gov, hop on the chat or hop on the Q&A and ask your question. There's a question here as well. It's a little complicated. Let me just kind of read it as best I can. Came from Jean and Olga Seiss. It says that their broker does not allow anyone in the office to use the coming soon status in the MLS. Their concern is that this is a violation of the Realtor's Code of Ethics. Any thoughts or opinions on that? Well, if you're asking me, does using coming soon status violate the Realtor Code of Ethics? Number one, it's not for me to say. Okay. Realtors interpret, you guys interpret your own code of ethics. My observation, though, is basically if you're complying with MLS rules, as an observer, I'm going to say typically that's not considered a violation of the Code of Ethics. Right. I mean, the MLS aren't going to have rules that if you follow their rules, you're violating the Code of Ethics. I mean, MLS is trying to make sure. So it's not my final say on this, but that's sort of my gut reaction. If you're okay with the MLS, you're not violating the Code of Ethics. Very good. So another question that came in, it says, it's regarding rent. It says if rent is paid via or using the VASH program, VASH, but the tenant is not paying their portion,
can they be evicted if they are not paying their portion, or if not, they pay the 25% of the lesser portion? I'm not sure if you're familiar with the VAS program.
Yeah.
You are, okay.
I think I understand what that means. Well, the point is, okay, so a tenant's not paying their portion, then normally I'd say, yes, you can evict them, unless they have a COVID reason why they can't afford to pay their portion. So starting October 1st, you could send them this 15-day notice, say, you got to pay, and this 15-day notice is going to be attached to a declaration. If they sign the declaration under penalty of perjury and return it in 15 days, and they say, I can't even afford to pay my portion. I mean, I have such a reduction in income. I have so many extra expenses related to COVID. I'm taking care of someone. I'm sick myself. I got extra childcare. If they're willing to say that under penalty of perjury, and they return this within 15 days, you're not going to be able to evict them until February 1st. Okay? I mean, if that's what they say, and they don't have to provide any documentation. It's just on February 1st, you'll be able to sue them, but you still won't be able to evict them for not paying that money. Now, starting February 1st, you'll be able to evict them no matter what for not paying the rent. But you won't even be able to evict them on February 1st for the non-payment they made during these 11 months. You will be able to sue them for the money, but you won't be able to actually evict them if they signed a declaration that they had a COVID reason. That means they owe you the money. They owe you every cent that they didn't pay, but you won't be able to evict them for not paying. Starting February 1st, then you'll be able to. And remember, starting October 1st, you will be able to evict them for other reasons. Okay.
Okay, so in that case, we'll segue right into this question from Teresa Keller. She says, is a 3-day pay or quit gone, or can it still be used?
It's gone for the time being.
Yeah.
It's gone until, I mean, it depends if it's pay or quit. Yeah, if it's 3-day notice to cure a covenant that's unrelated to paying rent, right? They all of a sudden they're violating the no pet policy, or they're subletting. Then you can still do the 3-day notice to cure covenant or quit. But the 3-day notice to pay rent or quit, no. If they're not paying the rent, you got to send them the 15-day. Maybe it's not COVID related, so you give them the 15-day notice. And if they don't want to sign a declaration that they have a COVID reason, then you'll be able to proceed. But so the 3-day notice to cure covenant will still work now for a non-COVID reason, but the 3-day notice to pay rent, you're not going to be able to use that from now all the way until February for the next 5 months.
Okay. So the question says, is C.A.R going to come out with a declaration of hardship form?
Oh yeah. Oh yeah.
Okay.
So all these forms are, and remember there's actually, I'll say it again because it's so complicated. There's actually 6 new forms. There's a 15-day notice to pay rent if they didn't pay between March 1st and September 1st. There's the 15-day notice to pay rent if they don't pay the rent after September 1st. And the reason that form's different is because that's going to tell them they got to pay at least 25%. But whichever one of those 2 forms you use, there's going to be attached to it the declaration for them to sign if they want to contest it. And also there's going to be a disclosure form that's also going to be attached. So let's say I'm a landlord, and here we are, October, and my tenant didn't pay the rent for June and July, and I don't think they had a COVID reason. I'm going to serve them with the 15-day notice for the rent that they didn't pay June and July, and attached to that is going to be a declaration for them to sign if they want to sign it, and a disclosure just explaining their rights. Now, if they don't pay rent after September 1st, or if they don't pay at least 25%, and I want to evict them for that, I'm going to send them a different form, the 15-day notice for after September 1st. And that form's going to be a little different because it's going to tell them, you didn't pay the 25%. But that same form is also going to have the declaration attached to it and the disclosure explaining their rights. So they'll get that, and then they return the declaration if they want to. So there's the 15-day notice for non-payment prior to September 1st, the 15-day notice for non-payment after September 1st. That's 2 forms. Attached to both of those will be a declaration and a disclosure form. That's 4. And then the last 2 are, let's say they paid the rent, but they didn't pay the utilities or they owed or something like that. So it's an they paid the rent, but they didn't pay something else. There'll be a 15-day notice to give them for not paying their financial obligation, to cure covenant, to pay their financial obligation if that was between March and September. And then if they didn't pay the utilities sometime after September, you'd give them the notice to cure the covenant of that financial obligation. And that will also, of course, attach to the declaration and the disclosure form. So all of these 15-day notices will have attached to them the declaration and the disclosure form. So it's a total of, and one more form I forgot. One more attachment is, remember, if the tenant makes more than 130% of the median income in the county. And how do you know this? Because when you took their application to rent in the first place, you got their income. And you looked at that and you say, well, that's definitely more than 130% of Riverside's income. For that tenant, you can send them an additional form saying, since you're a high income tenant, you need to provide documentation within 15 days proving that you really did have a loss of income or increased expenses. Remember, if it's not a high income tenant, they don't have to give you documentation proving that they lost income or proving that they have extra expenses. If they sign the declaration under penalty of perjury, that's all you get. So 4 new 15-day forms, 2 of which you're probably not going to use very often. Usually, you're not usually evicting people for not paying utility or something like that. So the 2 big ones are the 15-day notice to pay rent owed prior to September 1st. The second one, 15-day notice to pay rent due after September 1st. And with both of those forms, you'd be attaching a declaration and the disclosure form. It'll all be together in a package. And like I said, if you just say the heck with it, I'm just not going to do anything, you don't submit these forms, you can just wait till February 1st and then sue them for the money. But if you think, but maybe the tenant's not willing, maybe the tenant really doesn't have a COVID reason and they don't want to risk perjury, send them this form. If they don't sign it, go ahead and evict them right now, or at least starting October 1st. Because perjury is serious. If tenant signs that form saying they had a reason, and you can prove later that they didn't have a reason when they signed it, they can go to jail for that. So I don't know how that's all going to work. So I don't know if tenants, but the point is, those are your options. And those are the forms. They should be out in a few days. You can't do anything till October 1st anyway. Okay.
Right. Okay, a few more questions here.
Yeah.
We talked a lot about tenants. Obviously, this question came in. It says, what protection does a landlord or property owner have to pay his mortgage if the tenants are not paying rent? Are you familiar with anything on that side?
Yeah, you've noticed it's not very fair to landlords that they don't really get protections. Here's the only protection. First of all, there's this thing called forbearance. So if you owe money, and this is something, let's say you owe money to a lender and it's a federally related loan. It's an FHA loan, it's a VA loan, or it's a conforming loan, Fannie Freddie. You can apply for forbearance. And basically, since you have a COVID reason not to pay the mortgage, basically because your tenant's not paying you for a COVID reason, then the lender has to give you forbearance. What does that mean? That means they can't foreclose on you. They have to allow you to delay the payments that you're making. You can either delay them to the actual end of the mortgage, or you can pay it back over time. You have these rights as a property owner. If you have a COVID reason not to pay your mortgage, and your tenant not paying your rent for a COVID reason means you have a COVID reason, okay? But what if your lender what if it's a jumbo loan or not a federally related loan? It's just a regular loan. Well, the same law that just got passed Monday says all lenders in California are supposed to work with landlords to give them the forbearance if they qualify for it. So basically, if you want this forbearance, if you have a COVID reason not to pay your mortgage, then you can talk to your lender about getting a forbearance. The problem, of course, is you're still going to owe the money eventually. Just like a tenant's going to owe the money eventually too, right? I know what you're thinking if you're a landlord, though. Those tenants are never going to pay me. I'll sue them in February and I won't get anything. Well, be that as it may. The point is, there's no forgiveness here. Tenants ultimately owe the money, and landlords ultimately have to pay your mortgage. Tenants, though, if they have a COVID reason not to pay the rent, you can't evict them until February. And landlords, if you have a COVID reason not to pay your mortgage, talk to your lender. They have to work with you to give you a forbearance if that's the reason you're not paying your mortgage. So.
Okay. Just a couple more questions here. ADUs are becoming very popular. Question came in from member D'Amica Mejia. She's asking, how are ADUs being evaluated? Is it the same criteria as the main house? Is it all getting folded in as one single property, even though they may be detached?
Now, when you say evaluated, you mean to see if they're legitimate?
From an appraisal standpoint, how is are you familiar with the appraisal guidelines relative to ADUs?
That's a good question. That's not my area. That's, I don't know how lenders really approach that. I mean, we have this hotline at C.A.R, this lender, it's called, what the heck is it called? Call the legal hotline and we'll transfer you. The point is,
okay.
We have this guy who talks to lenders and he can help you with questions like that, like how do lenders deal with things like that. He's very good. And it's a hotline. We got the COVID hotline. We got the legal hotline. I think it's called Transaction Rescue. I believe it's called the Transaction Rescue Hotline. And this is a lender expert, and he'll talk to you about lender issues. Paul Herrera, I better take this question.
Yes.
Just to complicate our lives, yesterday, one day after California passes this sort of eviction moratorium thing, the federal government, the CDC, passed their own nationwide eviction moratorium, saying nationwide, then no residential evictions if the tenant signs this federal declaration form. Well, number one, it's not clear that the CDC actually has the power to do this. So we're not 100% sure whether this is even valid. Number two, I mean, it's basically the same thing as the California law, right? And the California law actually gives the tenant a little bit more protection because it extends longer. So this federal law says if your state gives more protection to the tenants, then this federal law doesn't really matter. And since the state of California already says, and by the way, I should repeat, this federal thing only says no evictions if the tenant has a COVID reason not to pay, which is the same thing the California law says, right? The California law says you can evict someone for not paying the rent unless they have a COVID reason. Well, the federal law basically says the same thing, but it only goes to the end of the year. So the state law goes a little longer. So the state law is basically stronger for the tenants. And the state law says you can't even evict them in February for non-payment of rent for a COVID reason. You can only sue them in court. Whereas this new federal law doesn't say you can't evict them for not paying this rent. It just says you can't evict them until the end of the year. Bottom line, not sure the CDC even had the power to do this. And number two, if they did have the power to do it, California's law that I just talked about is more protective of tenants. And this federal law says it doesn't supersede any state laws that are more protective of tenants. Therefore, at this point, I don't think we care about the CDC action.
Okay. One last question. I want to be sensitive to your time. I want to get this wrapped
as long
up.
as you want. Yeah.
Okay. So question came in. It says from Yvonne Leonard, one of our board members, says, are there any changes planned for the VP? Due to COVID-19 exposure, I recently had to do a final walkthrough via FaceTime. Seller gave buyer access to the property so that final walkthrough could be done.
I'm not sure what Yvonne's question is. Yvonne, are you saying that the seller didn't allow the buyer to do a walkthrough in person? I mean, maybe that's what they're saying. In other words, a walkthrough is like a showing, right? I mean, if a buyer is entitled to do it. So, I mean, I mean, theoretically, the seller controls this process. The seller could just say, maybe what you're saying is the seller allowed regular showings, but they're not allowing an actual walkthrough. Seller says, it's my house. If I don't want to let you in, I don't have to let you in. The buyer can say, though, yeah, but the contract says I have the right to do this. You don't have to let me in, but if you don't let me in for the walkthrough, I'm not going to close the deal because that's breach of contract. So, I mean, if the buyer's okay with the virtual walkthrough, that's okay. But if the buyer says, hey, in other words, Yvonne, I don't think we're going to change the form. I think what you're saying is, would we change the rules to say that the buyer is not entitled to a in-person walkthrough? I don't think that.
She did add one. She just added a sentence that says she's really asking about the additional protection for the buyer's agent within the VP form.
Protection from what? I'm wondering what your actual concern is.
Well, we'll see if she responds any further with any further detail on that.
I see.
John, maybe just like a minute or two. Do you want to talk anything about some of the propositions that are coming up on the ballot in November?
Yeah, I'm not the super expert on those either.
Okay.
Other than number one, there's Prop 19. That's the one C.A.R. supports. That's the one I would say you should probably vote yes for, because this will enable people who are over 55 to take their property tax they're paying on their current property, going anywhere else in California, and take that low property tax that they're paying to the new house, even if the new house costs more or costs less, they can transfer that property tax rate. And this whole thing is also going to raise a lot of money for local governments anyway, because sort of the price paid to get the support of this was that certain transfers that were previously not taxed, that didn't trigger reassessment, will trigger reassessment, namely when a parent transfers property to a child or grandchild. But the good news is you can still transfer property to a child with no reassessment if the child or grandchild is going to use it as their primary residence. And it also doesn't apply to transfers of family farms from one generation to another. It's just transfers of other types of properties, not farms, not primary residences, from a parent to a child. Traditionally, this didn't trigger reassessment. Now it will, but that's sort of the price we sort of had to give up to get the support of everyone. And everyone is supporting this, basically saying, good, that's going to raise a lot of money. Plus, this should increase a lot of transactions because there's so many people like me, for example. I have to think about, if I move right now, I'm going to have a serious property tax increase. If this gets passed, I'm not going to have this serious property tax increase. So I'll be hiring some realtor out there to help me move if this gets passed. So anyway, that's the deal. Prop 19. The other one, Prop 15, split roll. That's the one. I mean, C.A.R. is always against tax increases like this. This is the one that would increase, that would say Prop 13 doesn't apply to commercial, it just applies to residential. As Mark and I were talking, I don't think it's polling very well. Anyway, most people don't like tax increases, but anyway, that's the only two that are really significant, I think, Prop 19 and Prop 15.
Great. Okay, one last question came in from Vicky Carpenter. It says, more sellers are selling and renting so they can take time to find a home because of limited inventory. The seller purchase replacement property only addresses if purchasing. With limited homes and rentals, can that form be modified for seller contingency to find rental or replacement property?
Okay.
That's a long one.
Vicky's not, my friend Vicky is not asking a question. She just has a good suggestion. And Vicky, I will definitely pass that along. Vicky, why don't you just email me that, make it easier for me, govh@car.org. And we'll make sure the forms committee, I think it's a good idea. Because you're right, things have changed and some sellers are trying to do that. So that takes care of the Q&As. Let's see. Oh, okay. Anonymous attendee, when is the new purchase contract coming out? End of next year. So you don't have to worry about a new purchase contract until the end of 2021. Nothing's going to change before then. I see Yvonne came back and said the concern for the agent fulfilling their duty to the client. Yeah, good question, Yvonne. I wouldn't worry about that. I mean, if the seller doesn't allow it, it's not like you can't go in there if the seller won't allow it. So it's not your issue. You're doing the best you can for your buyer. If the seller doesn't allow it, the seller doesn't allow it. So
very good.
I'd say that.
Well, Gov, thank you. I just want to let everybody know this particular video Zoom webinar will be on IVAR's website by next week, so you can access it there. And we'll also be sending it out to our membership via an email with a link attached. A number of the documents that and form updates that Gov was talking about will also be available on IVAR's website. So pay attention to your emails. We'll be letting everybody know about that. I just want to thank Gov, once again, thank you so much for participating in today's webinar. As always, you do a great job of keeping everybody informed in the changing environment of the legal world and how it impacts us as realtors. And good luck for the rest of the year. If I don't talk to you, have a great rest of the year. And I'm sure we'll be circling back in 2021 with lots more new questions as we address COVID-19 and our industry. So with that, I will be closing out the meeting. I want to thank everybody for participating in today's event. Thank you. Have a great day.
Thank you, Mark. Okay, bye-bye.
Very good.